Welcome to the deep dive. We're plunging right into a really fascinating judgment today from the Supreme Court of India.
Absolutely.
This isn't your standard legal case. It's quite a human story, a marital dispute with some incredible twists and turns.
Yeah.
We're talking divorce, second marriage happening quite quickly, and then a high court decision that really threw a spanner in the works.
It really did. And I think this case, it just beautifully shows how courts have to grapple with these messy, complex human lives that don't always fit neatly into, legal boxes or precedents.
That's a great point, the messiness of it all. And our source here for you listening is the judgment itself, dated August 14th, 2025. It lays out all the details.
All there in black and white.
So let's start at the beginning. The couple married back in February 2009.
Okay.
And they had a son in April 2010. But things clearly went south because by September 2012, the husband filed for divorce.
Right. On grounds of cruelty and adultery, I believe.
Correct. Cruelty and adultery. Now, the family court in October 2016 did grant the divorce, but only on the grounds of cruelty. The adultery part wasn't proven.
Okay, so cruelty was the basis.
Exactly. But here's where it gets really interesting. Just a few months later, March 5th, 2017, the husband remarries.
Wow. Okay, so divorce granted, he moves on, remarries.
Pretty much. But then the high court steps in, August 24th, 2018, and they completely overturn the family court's divorce decree.
Completely set it aside. And their reasoning was quite specific, wasn't it?
It was. They basically said the wife couldn't be held responsible for her father's rude utterances. That was the main instance of cruelty the family court relied on.
Which is fascinating. How much do you hold someone accountable for their family's behavior in a marriage dispute? It's a tricky line.
Definitely. And think about the implications.
Yeah.
The high court says no divorce, but the husband's already in a second marriage.
Exactly. A huge legal tangle.
Yeah.
So naturally, it ends up at the Supreme Court.
Right. What happened there? Any chance of reconciliation at this point?
Well, they tried mediation, but honestly, it failed completely. And you have to look at the reality. They'd been living apart since 2010.
So nearly 15 years by the time the Supreme Court heard it.
15 years. Zero chance of getting back together. It was an irretrievable breakdown.
Clearly.
So, given this absolute deadlock, the Supreme Court did something significant. They used their power under Article 142 of the Constitution.
Article 142. That's their power to ensure complete justice, right? Even if the standard laws don't quite cover it.
Precisely. It's a discretionary power for exceptional situations.
Mm-hmm.
And they decided this was one. They used Article 142 to dissolve the marriage, finally.
Okay, so the marriage is dissolved, but complete justice often involves more than just the legal status, doesn't it? What about finances, the son?
Absolutely. The court ordered a pretty substantial one-time payment, 1.25 crore rupees.
Wow, okay. Rupees 1 crore 25 lakhs as permanent alimony.
Permanent alimony for the wife and the son. And it wasn't just a lump sum dropped in their lap. It was structured.
How's
5 equal quarterly installments. 25 lakhs each time, running over a year from September 2025 to September 2026.
Okay, that sounds practical.
But, and this is crucial, there was a very strict condition. If the husband defaulted on even one payment,
Yes.
the entire Supreme Court order dissolving the marriage would be recalled. And any money he'd already paid, forfeited, gone.
That's a serious condition.
Yeah.
Really holds his feet to the fire, ensures compliance.
It shows the court wasn't just making a ruling. They were trying to ensure a genuinely fair and, importantly, enforceable outcome for everyone, especially the wife and child.
So when you step back and look at this whole saga, what's the big takeaway for you listening in?
Well, I think it really drives home the power and perhaps the necessity of something like Article 142.
How so?
It allows the highest court to cut through immense procedural knots and human complexities, like an invalidated divorce after a remarriage, 15 years of separation, things that just don't have easy answers in the statutes.
It's about achieving a just result on the ground, not just a technically correct one, adaptability.
It's exactly. Prioritizing a fair, practical, human outcome over maybe rigidly sticking to precedent or procedure that just doesn't fit the situation anymore.
Which leaves us with a final thought, doesn't it? How essential is it for our legal systems, really, to have this kind of built-in flexibility, this ability to find practical, equitable solutions when people's lives, in all their messiness, just don't conform to the neat lines drawn by the law? Something to ponder.